a process server handed me an envelope on my own front porch on a Tuesday afternoon, and inside it was a legal filing from my son's biological father asking a judge to recognize him as a legal parent, 6 years after he signed a document giving up exactly that claim. I'll call him Chris. He was my husband's best friend since college, my son's favorite person for most of his 6 years on Earth, and until about 14 months ago, someone I'd have trusted with my child's life without a single second thought. I want to walk through this slowly, because the version people hear when this kind of thing goes viral is just the filing and the fight. It skips the part where he used to be family. That part matters more than people expect it to. The pattern, before I understood it, was a pattern. My husband Mark can't have biological children, a fertility issue diagnosed the same year we got married. One of those facts that reorganizes an entire future in a single afternoon in a doctor's office. Chris offered to donate before we'd even fully processed what that diagnosis meant for us. He said he wanted to do something real for the two people who mattered most to him. I believed him completely. I still believe he meant it completely, back then. I remember the actual conversation where he offered, because it's not the kind of conversation you forget. The three of us were at our kitchen table, maybe 8 months after Mark's diagnosis, in the specific low place you get to after enough failed appointments and enough careful, hopeful plans falling through. Chris said he'd been thinking about it for weeks and didn't want us to feel like he was offering out of pity. He said he was offering because he loved us both and couldn't stand watching us grieve something that, for him, would cost almost nothing to give. Mark cried at that table. I'd never seen him cry like that before, not even at the original diagnosis. I remember thinking, watching the two of them, that I was witnessing the kind of friendship people don't usually get to witness up close. There were 2 years before that offer that I don't talk about much because they're not really this story, but they're the reason the offer landed the way it did. 2 years of appointments, 2 failed rounds with donor sperm from a bank neither of us felt any connection to, a specific Tuesday where I sat in a parking lot outside a fertility clinic and couldn't make myself walk back in for another blood draw. Chris had been around for most of that, not centrally, just as Mark's friend who showed up sometimes with takeout and didn't ask questions. I think, looking back, those 2 years are part of why his offer felt like it came from somewhere real instead of somewhere performative. He'd watched the actual weight of it up close before he ever offered to help carry it. We did it properly, or we thought we did. Our attorney, a reproductive law specialist named Rachel, drew up a full donor agreement. Chris relinquishing any parental rights or claims, us assuming full legal and financial responsibility, everyone's expectations in writing before a single appointment happened. Chris signed it without hesitation. He told us, at the signing, that he didn't want anything from it except knowing he'd helped. Here's what I didn't examine closely enough over the 6 years since. The way you don't examine things that feel like love at the time. Chris stayed close, closer than a donor usually stays, though I didn't have a comparison point, since he was also Mark's best friend independent of any of this. He came to every birthday. He asked, more than once over the years, whether Theo, that's our son, had said anything new, learned anything new, in a tone that sometimes felt like an uncle's pride, and sometimes, in hindsight, felt like something else entirely. 2 years ago, Chris's marriage ended, and he had no kids of his own from it. Something shifted after that. He started showing up more. He bought Theo a bicycle for his 5th birthday that cost more than what the rest of us combined had spent. And when I mentioned, gently, that it felt like a lot, he told me he just wanted to be generous with a kid he loved. Around the same time, he started correcting people at family gatherings. Not us, other people, distant relatives, when they called him Uncle Chris, saying something like, "Just Chris is fine," in a tone I registered at the time as humility, and now read completely differently. 8 months ago, at Theo's 6th birthday party, Chris knelt down in front of him, in front of a yard full of people, and said, "You know you have my eyes, right, buddy?" Theo, 6 years old, said something like, "Cool," and ran off toward the piñata. I remember the specific way my stomach dropped watching that exchange, and I remember telling myself I was overreacting, because Chris had never said anything untrue. Theo does have his eyes. That's just genetics. That's just a fact. I know now it wasn't a fact he was stating. It was a claim he was rehearsing. There's one more moment I keep coming back to, smaller than the birthday comment, but somehow just as telling in hindsight. 6 months ago, Chris asked if he could be the one to pick Theo up from school, just once, as a treat, since he happened to be in the area. I said yes, because it seemed harmless, and because saying no to Chris had never occurred to me as something I might need to practice. Theo's teacher mentioned to me afterward, kindly, just making conversation at pickup the next day, that Theo had told his class Chris was kind of like his other dad. I laughed it off in the moment. I didn't sleep well that night, and I still couldn't have told you exactly why. How we ended up here, and the piece of paper I forgot mattered. I want to back up and tell you about the year we actually did this, because there's a detail from that year that ended up being the entire spine of what happened later. The same way these stories always seem to hinge on some boring piece of paperwork nobody thought much about at the time. Rachel, our attorney, told us during the original process that a signed donor agreement alone wasn't always airtight in every jurisdiction, especially in a known donor situation where the donor stayed involved in the child's life afterward. She said the strongest protection wasn't just the agreement. It was Mark completing a second parent parentage judgment establishing him, legally, as Theo's only second parent, closing off any ambiguity a court might otherwise have to interpret later. She told us most couples skip this step because it feels redundant on top of the donor agreement, and she said she'd seen exactly the kind of situation, years later, where skipping it mattered. I remember sitting in her office that day, 7 months pregnant, exhausted, wanting nothing more than to be done with paperwork forever, and just meet our son. Mark asked her, half joking, whether she thought Chris would ever actually try something like that. She told him, evenly, that she didn't think Chris would. Not at the time, not knowing either of us. She said she wasn't drafting the parentage judgment because she distrusted Chris specifically. She said she drafted it that way for every client, in every known donor arrangement, because grief and years have a way of changing people's minds about decisions they made with total sincerity at 28. Mark did it anyway, the same year Theo was born, mostly because Rachel is thorough and we trusted her completely. It cost about $1,100 in legal fees, took maybe 6 weeks, and produced a document neither of us thought about again for 6 years. It went in a folder with Theo's birth certificate and social security card. I genuinely forgot the parentage judgment existed as a separate document from the donor agreement until Rachel reminded me of it, 14 months into this whole situation, in a phone call I'll get to. 2 weeks before the process server showed up, a mutual friend named Priya, not our attorney, a different Priya, Chris's downstairs neighbor and someone we'd known socially for years, mentioned to me at a farmer's market, carefully, like she wasn't sure she should say anything at all, that Chris had been asking her boyfriend, a paralegal, questions about parental rights for donors over drinks a few weeks earlier. She said she'd almost called me right then and talked herself out of it, because it felt like gossip, not information, and she didn't want to cause a problem over something that might turn out to be nothing. I told her I appreciated her telling me even now. I didn't fully let myself absorb what she'd said until the envelope showed up 2 weeks later, and I've thought since about how much of this entire ordeal might have gone differently if I'd taken that farmer's market conversation more seriously in the moment, instead of filing it away as something to worry about later. The process server came on a Tuesday in April, while Theo was still at school. I remember exactly what I was doing, folding laundry on the living room couch, some show playing quietly in the background that I couldn't tell you the name of if you asked me right now, when the doorbell rang, and I remember the specific formality of the man's voice asking if I was who I am, before handing me an envelope and leaving without another word, back down the porch steps, into a gray sedan I watched pull away through the front window. I stood in the doorway for a full minute before I opened it. Some part of me, I think, already knew from the formality of the delivery that this wasn't a birthday card. Inside was a filing, from an attorney I didn't recognize, on behalf of Chris, asking the court to recognize him as a legal parent to Theo based on what the filing called his established, ongoing parental relationship with the child over the past 6 years. The birthdays, the visits, the bicycle, all of it, reframed in legal language as evidence of a father, not an uncle. I sat down on the stairs and read it twice before I called Mark. My hands weren't shaking, which surprised me, because everything else in my chest was. Mark came home early, and I met him in the driveway before he'd even made it to the door, filing still in my hand. He read it standing there, engine of his car still ticking as it cooled behind him, and I watched his face do something I hadn't seen it do since the day of his original diagnosis. A specific kind of stillness that isn't calm, it's just shock wearing calm's clothes for a minute. He said he needed to sit down. We sat on the front steps, the filing between us. And he said he kept trying to find the version of Chris he'd known for 20 years, inside the version of Chris who'd apparently hired a lawyer to argue his way into being Theo's legal father. He said he couldn't find it. He said that scared him more than the legal filing itself did. He also said something I wasn't expecting, and I want to include it, because it matters for how complicated this whole thing actually is. He said part of him understood, in a way he hated understanding, because he knew what it was to want to be a father, and to lose that in ways beyond his control, even if his version of losing it and Chris's version weren't remotely the same thing. I asked him, gently, what he meant by that. He said he'd spent years grieving a version of fatherhood that biology had taken from him before Chris ever offered anything, and that some tiny, uncomfortable part of him could imagine what it might do to a person to give away that exact thing on purpose, and then watch, year after year, as someone else got to live inside it completely. He said understanding that didn't mean he thought Chris was right. He said it just meant he wasn't going to let himself turn Chris into a cartoon villain, even now, even with a legal filing sitting on the step between us. I told him I respected that, and that I was also going to protect our son regardless of how much sense Chris's grief made to either of us. He said he agreed completely. He just needed to say the complicated part out loud once before he could move fully into the part where we fought it. I called Rachel that same night. She'd handled our case 6 years earlier and still had every document on file, which turned out to matter more than either of us expected it to. She asked, before anything else, whether Mark had ever completed the second parent parentage judgment she'd recommended. I told her he had. I remember the specific quiet on the line for a second before she responded. She told me that judgment was likely going to be the single most important document in this entire case. She said a donor agreement establishes intent at the time of conception, but a parentage judgment is a court order, a different, stronger category of legal fact, one that most courts treat as close to conclusive on the question of who a child's legal parents are, especially when it was entered without objection at the time, and has stood unchallenged for 6 years. She said Chris's attorney was going to have an extremely difficult time arguing around an actual court order that already settled the exact question they were now trying to reopen. She asked if we still had the original folder. I told her it was in the filing cabinet in our office, exactly where it had been for 6 years, untouched. She asked me to scan every page that same night and send it to her before morning, and I heard, underneath the calm professionalism of her voice, something that sounded almost like relief, the specific relief of a lawyer watching a piece of advice she'd given years earlier turn out to have been worth every bit of the trouble it caused at the time. She said one more thing that stuck with me. She said the donor agreement protects intent, the parentage judgment protects fact, and courts, generally, care a great deal more about fact. My sister came over the next night, and I told her everything. The filing, the birthday comment about the eyes, the bicycle, all 6 years of small moments I could now see stacking into something I hadn't wanted to look at directly while it was happening. She asked me, gently, whether I thought we'd made a mistake keeping Chris this close for this long. I told her I didn't know yet. She said she wasn't trying to blame me. She just wanted to understand what I actually believed, because she could tell I was still working that part out in real time. She reminded me of something I'd half forgotten, actually. A conversation from maybe 3 years ago, at a family barbecue, where she'd pulled me aside and asked, almost offhand, whether it was normal for Chris to know Theo's teacher's name, his soccer schedule, small logistical details that even some actual uncles wouldn't bother tracking. She said she'd told herself at the time it wasn't her business, and she said she regretted that a little now. Sitting in my kitchen 14 months into a lawsuit she'd seen the shape of years before either of us had a filing in hand. I told her the truth, which is that I still don't fully know how I feel about any of it. Chris was Mark's best friend before any of this. He gave us our son. Keeping him close felt like gratitude, not danger, for most of 6 years. I don't think I'd undo that closeness even now, knowing where it led. I think I just want to go back and set boundaries around it. I didn't know yet that we needed. About 3 weeks in, Mark asked me directly whether we should try to resolve this privately with Chris, before it went any further through the courts. One more conversation, man to man, old friend to old friend, before lawyers took over completely. I understood the impulse. I also told him I was worried that one more conversation was exactly the kind of soft, hopeful move that had let this drift for 2 years already, without either of us naming it clearly. I said I thought Chris had already decided what kind of story he was in, the same way people usually have by the time it gets this far, and that a private conversation at this stage was more likely to just give him a preview of our legal position than to actually change his mind. Mark sat with that for a while. He said he still wanted to try, once, mostly for his own sake, so that whatever happened afterward, he'd know he hadn't skipped the version where he simply asked his oldest friend to stop. I told him I understood that need, and that I wouldn't stand in the way of it, even though some part of me still worried about what it would cost him. Mark called Chris the following weekend. I wasn't on the line, but Mark told me everything afterward, sitting at our kitchen table with a coffee he never drank. Mark asked him directly why he'd done this. Chris told him he didn't see it as taking anything away. He saw it as finally being honest about what he already was to Theo. He said he'd spent 6 years watching from the outside of something that half of him had helped create, and he said the loneliness of that, especially after his marriage ended and he came home every night to an apartment with no kid in it at all, had become something he couldn't keep swallowing quietly. Mark asked him what he thought honest meant, given the document he'd signed 6 years earlier with his own signature on it. Chris told him that document was written before he understood what it would actually feel like to watch a kid who was biologically his call, another man dad for 6 straight years. He said he wasn't the same person at 28 who'd signed it, and he asked Mark, almost pleading by that point, whether Mark could honestly say he'd have felt any different in Chris's position. Mark told him he understood that feeling might be real. He told him it still wasn't Theo's job to fix it, and it definitely wasn't a court's job to rewrite 6 years of a child's life, to make an adult feel better about a decision he'd made freely, with a lawyer, as a grown man. He said he was sorry Chris was in pain. He said being sorry about that didn't mean he was going to let it become Theo's problem to solve. Chris told him the case was already filed. He said he wasn't backing down. Mark said the last thing Chris said to him, before hanging up, was that he hoped Mark would understand someday. Mark told me he already understood. He just didn't agree that understanding obligated him to lose his son over it. About 2 months before the hearing, Chris's attorney sent a proposal through Rachel. Chris would drop the parental rights claim entirely in exchange for a formal, court-ordered visitation schedule, something like every other weekend. Holidays split, the structure of an actual custodial arrangement without the legal title attached to it. Rachel walked us through it carefully, without pushing us either direction. She said some families in our position took offers like this, mostly to end the stress and legal costs faster, and that there was nothing wrong with considering it. She said she just needed us to understand what we'd actually be agreeing to, not a return to the informal, flexible Uncle Chris arrangement we'd had for 6 years, but a binding legal schedule, enforceable by the same court, that neither of us would be able to adjust unilaterally afterward if it started feeling wrong. Mark and I talked about it for 3 days. Part of the appeal was obvious. No hearing, no more months of waiting. Something that looked, on paper, like it might let Theo keep a version of the relationship he'd always known. But the more we sat with it, the more it felt like agreeing to formalize the exact blurred boundary that had gotten us here in the first place, just with a judge's signature on it instead of a birthday card. I remember saying to Mark at our kitchen table that I didn't want Theo growing up with a legally mandated weekend schedule with a man who'd just spent a year in court trying to become his father. Mark agreed immediately. We told Rachel to decline the offer and proceed to the hearing. I've wondered since whether that was the right call, purely on the numbers. The hearing cost more in legal fees than the settlement would have, and it dragged the whole thing out 2 additional months we didn't have to spend in limbo. I still don't regret it. Some decisions aren't actually about the fastest exit. They're about which version of the next 15 years you can actually live inside. The court scheduled an early procedural hearing rather than a full mediation, mostly to address whether the case could even proceed, given the existing parentage judgment. Rachel warned us in advance that this hearing alone could effectively decide the whole thing, which turned out to be exactly right. I hadn't been inside a courtroom before, not really. Not for anything that mattered this much. and I remember being surprised by how small and administrative it all felt. Fluorescent lights, a court reporter typing quietly in the corner. Nothing like the version of this scene I'd built in my head over 14 months of imagining it. Chris was there with his attorney. I hadn't seen him in the 14 months since the birthday party, and he looked smaller than I remembered somehow, in a suit instead of the t-shirts he usually wore to Theo's parties. He didn't look at me. He looked, mostly, at Mark, in a way I found harder to watch than I expected. At one point, early on, before either attorney had said anything, his eyes moved to me for just a second, and I saw something there I hadn't expected to see. Not anger, something closer to embarrassment, like a man watching himself from outside his own body for the first time in over a year. His attorney argued the established relationship theory at length. 6 years of birthdays, the bicycle, the comment about the eyes. Framed now as consistent evidence of a functioning parental bond, the law should recognize regardless of the original paperwork. He used the phrase psychological parent 4 separate times, building toward the idea that law should follow lived reality rather than a 6-year-old signature. Rachel didn't argue with any of that framing directly. She said Chris's involvement in Theo's life had never been in dispute, and that everyone in the room, including her clients, was genuinely grateful for the role he'd played as an uncle figure for 6 years. Then she said the actual legal question before the court wasn't whether Chris loved this child. It was whether a valid, unchallenged parentage judgment, entered 6 years earlier and never appealed, could now be reopened based on a change of heart. She submitted the judgment into the record and asked the court to rule on the threshold question before any further proceedings continued. The judge took a recess to review it, 20 minutes maybe, though it felt considerably longer sitting in that hallway with Mark's hand tight around mine, neither of us saying much of anything. When she came back, she was direct, in a way I hadn't expected from a formal hearing. She said the parentage judgment was valid, had never been challenged within any applicable window, and that Chris's petition, as filed, didn't meet the legal standard required to disturb an existing, unchallenged parentage order 6 years after the fact. She said the case, as currently framed, wouldn't proceed further, and she noted, almost as an aside, that this was precisely the kind of situation second parent judgments existed to prevent. I watched Chris's shoulders drop the same way Mark's had dropped on our front steps 14 months earlier. His attorney leaned over and said something quiet to him. He didn't respond. He just kept looking down at the table, both hands flat against the wood, like he was bracing for something that had already happened. I felt something loosen in my chest hearing that ruling. A very specific relief, the kind that comes after months of not sleeping properly and not fully admitting to yourself why. Theo was never actually at risk of losing us. I know that now. I didn't fully know it for 14 months. But watching Chris in that room, a man who'd given us our son, sitting alone at a table with an attorney he was probably still paying off, having just lost the version of fatherhood he'd apparently convinced himself he deserved. I felt something else too, something that wasn't guilt exactly, because I don't think we did anything wrong, but wasn't clean triumph either. Mark told me afterward he'd felt the same thing, watching from 6 feet away, unable to fully separate the relief from the grief of watching someone he'd loved for 20 years lose something in a room with strangers. Chris didn't appeal. Rachel told us that was expected, given how clearly the judge had ruled on the threshold question. The case closed about 6 weeks later. Rachel mentioned, almost in passing, that his attorney's fees on a case like this typically ran into the tens of thousands by the time a hearing like ours happened, and that all of it had been spent arguing against a document that had been sitting quietly in our filing cabinet the entire time. We haven't spoken to him since the hearing. Mark tried once, a text a few months afterward, just asking how he was doing, no mention of the case. Chris didn't respond. Mark told me he didn't take that personally, or he was trying not to. He said he understood that some friendships end not because anyone was purely a villain, but because one person wanted something the other person was never going to be able to give him, and there isn't always a version of that where everyone stays close afterward. Some mutual friends took it hard in a different direction than I expected. One couple, close to both Mark and Chris since college, told us at a dinner months later that they understood why we fought it, but that watching a 20-year friendship end in a courtroom instead of a living room still felt like a loss for everyone, even the people who agreed we were right. I didn't argue with them. I told them I understood exactly what they meant, because some days I feel that loss too, even standing fully behind the decision that caused it. Mark's mother, who'd known Chris since he and Mark were 14, cried on the phone when we told her the outcome. Relief and grief in the same breath, the specific sound of someone glad for one thing and sad about another at the exact same time. She asked if there was any version of this where Chris eventually came back around, older, calmer, willing to just be an uncle again the way he'd promised at the beginning. I told her I honestly didn't know. I told her I hoped so, for his sake more than ours at this point, because Mark and I have Theo, and Chris, as far as we can tell, has spent 14 months and a great deal of money, ending up with less than what he had before he ever filed anything. Theo asked about Chris maybe 2 months after the hearing, the way 6-year-olds ask about things, sideways, in the middle of an unrelated conversation about dinosaurs, wondering when Uncle Chris was coming to visit again. I told him Chris was going through a hard time and might not be around for a while. He accepted that the way 6-year-olds accept most things, fully for about 10 minutes, then wanted to know if we could get dinosaur nuggets instead of regular chicken. He doesn't ask as often now. Sometimes, at a birthday party for one of his friends, he'll mention Chris out of nowhere. Chris used to do this trick with a quarter. Chris let him stay up late once during a sleepover, and I watch Mark's face do something complicated in those moments. Some mix of missing his friend and being glad, underneath the missing, that the fight is over. Don't know yet what I'll tell Theo when he's old enough to ask the real question, the one that isn't about dinosaur nuggets. I know it will be honest, whatever it is. I haven't figured out yet how honest a 6-year-old's version of honest needs to be, and I've decided that's allowed to stay unresolved for a few more years before I have to actually answer it. Here's what I actually took from this. Protecting your family doesn't require deciding the other person was a monster the whole time. Chris gave us the most important thing in our lives, and grief can turn generosity into entitlement in ways that are genuinely sad to watch happen to someone you loved. But I also learned that the boring paperwork, the parts that feel redundant when you're sitting in a lawyer's office just wanting to finally have your baby, are sometimes the only thing standing between your family and someone else's unprocessed grief 6 years later. Do the boring paperwork. Do all of it, even the parts that feel like overkill in the moment. I think about that farmer's market conversation with Priya sometimes, the one where I filed her warning away instead of acting on it. I don't blame myself for that, the way I might have a year ago. I've decided some warnings only make sense in hindsight, and you can't run your whole life treating every uncomfortable comment as a 5-alarm fire. I just wish, some days, that I'd called Rachel that same afternoon instead of 2 weeks later. It probably wouldn't have changed the outcome. Might have given us a little more time to brace for it. If you've ever had to protect your family from someone who used to be one of the people you trusted most, I'd genuinely like to hear how you got through it. Drop it in the comments. I read every single one.